Okay, so thank you very much for coming. We're particularly excited to have Mouhamadou here today, a good friend of the center, who wears, as we've just been discussing, so many enormous hats, distinct hats. So I'm going to work backwards. Mouhamadou is the founding executive director of the African Center of International Law and Practice, which is a really incredible think tank bridging the gap between international law and public policy, and Africa taking on a tremendous amount of a broad scope of work related to economic governance and investment law and policy. He is somehow also lead counsel of the Islamic Development Bank, where he's played all of the roles that a lawyer would in all of the complex projects of the Islamic Development Bank. And somehow on top of that, as you'll hear today, he's the project lead for the Organization of Islamic Cooperation's Investment Dispute Settlement Organ, and it's on that particular hat that we'll hear today. So thank you again very much, Mouhamadou.
Hi, good afternoon, everyone. I thank you, Lisa, for the good introduction, nice introduction. Yes, you're right, I'm wearing all these hats, and that's why probably I'm going to gray very soon. But I'm happy to be here, and thank you for inviting me to deliver this talk. I would first start by asking the audience whether they have heard about the OIC agreement before. Whoever has heard about it before, could you get your hand up? So it's good. It's a good number as compared to me back in 2011. I'll give you a small anecdote. I was a young professional at the Islamic Development Bank at the time, and I was requested to do a research on BITs, bilateral investment treaties signed among OIC member states. And then I delivered the research, and I was happy, very proud of what I did. And then one of my conclusion and recommendation at the time was that given the diversity of BITs signed by OIC member states, we should have a multilateral investment agreement among OIC member states. And I was so proud, I went to my boss and I delivered the paper. It was about to be published, and actually it got published. Until at some point someone sent a big email and said, well, there is an OIC investment agreement. So it just tells you how even people inside didn't know that this OIC investment agreement existed. So for me, it was a kind of shock that, as a passionate researcher, I made a policy recommendation that was not really needed because what I was proposing already existed. But it was a pleasure also because at that point, we needed to take it forward and then see what we can do with that agreement. 1 year later, I was invited to deliver a training at this UNCTAD and ISDB joint annual training on investment agreement. And I had to talk about the OIC investment treaty. Luckily, at the same time, the first case dispute under the treaty was raised against Indonesia by a Saudi investor. So it was the first case, Al-Warak, against Indonesia under the OIC investment treaty. And the message I delivered there at the time was to say that this first case is going to be a landmark case, and it's going to open up so many cases under the OIC investment treaty. And today, I think my prediction was right, because since 2012, not less than 8 to 9 cases have been brought under the OIC investment agreement. So you can guess what would happen from a policy point of view and from the state, OIC member state point of view. We had an agreement, the OIC agreement dated 1983. And then let me go back to my slide maybe. Then we talk about a little bit about, adopted in 1981. So you would imagine in the context where we are talking about reforming investment treaties, BITs, and how that old treaty could be very, very old in its provision, and how a reform was needed of this agreement. So it entered into force in 1988. It is an agreement signed. OIC, by the way, stands for the Organization of Islamic Cooperation. formerly Organization of Islamic Conference. It is made of 57 member states. It is actually the largest organization after the UN. 57 member states from Asia, Africa, Middle East, and America, even because you have countries like Suriname who are member countries of the OIC. And it is ratified, the agreement, the OIC agreement itself is signed by 36 member states, ratified by 29 member states. And it has an ISDS provision, which is Article 17, which says in case of disputes, parties will go to arbitration between states and investors. So, and that is until a permanent organ is established. And then, as I said earlier, the first ISDS case was under the Article 17, was Al-Warak against Indonesia in 2012. And as I said also, since then, 6 to 8 cases have been brought. Now, member states would definitely, in this context, have, sought to amend the OIC in dispute settlement provision. Because as you would imagine, there is a lot of talk, and as you know, there is a big debate currently about reforming ISDS system, and the working group 2-3 at UNICITRAL is working on that. And for us, it was an opportunity to also take stock of what is happening. And we had a golden opportunity because we have already a treaty where we can implement a system or a case where we could implement whatever recommendation is coming out of the discussion at UNICITRAL. So member states, when they saw all these disputes happening, said we need to reform Article 17 because it is old. It is not necessarily reflecting our initial intention and will when we were signing and ratifying the OIC treaty. And then it's how the investment promotion agencies of the OIC met in 2016 in Riyadh and recommended formally that Article 17 be amended. The ISDS provision basically to be amended. Subsequently, in the same year in Tashkent, the Council of Foreign Ministers of OIC met in Tashkent and formally adopted a resolution recommending OIC institution, OIC Secretariat in coordination with OIC institution to start reforming Article 17. And between 2016 and 2019, that's where I was appointed to lead the project of reforming the OIC dispute settlement mechanism. And then between then, a lot of steps have been crossed, including preparing a concept note that was discussed among the OIC institutions and the OIC Secretariat General. And that concept note went to the Council of Foreign Ministers in Abu Dhabi in 2019, and they formally adopted the concept note, which had some recommendations and way forward in terms of amending Article 17 of the OIC Investment Treaty. But at the same time, they requested the Council of Foreign Ministers, which is made of the Ministers of Foreign Affairs of the 57 member states of OIC. They recommended that the concept note and the protocol, because we are going to have an investment protocol as an additional protocol to the OIC investment agreement that will focus on dispute settlement. So they formally recommended that these documents, the concept note plus the investment protocol, be discussed within a member country's expert group. So that's where we are. And as of today, the protocol is ready, the concept note is ready, and we are going to meet. The expert group meeting is going to convene to discuss the policy proposals, the proposals and concept note and the protocol that has been already developed to move forward with the OIC for a Council of Foreign Ministers to adopt the protocol hopefully in March 2020. And from there, that system would be, after entry into force, of course, will be replacing the current system of ISDS we have. So that was just to give you a little bit of background in terms of where we are coming from and where we are currently, and before starting to discuss really what are we proposing currently in terms of reforming the ISDS system and how it is a contribution to the debate, a South-South contribution to the debate. I must start by saying that whatever I'm going to say here is still at the stage of proposals, because member states have not yet adopted it. They are sovereign, and they are the ones who are going to adopt the protocol and the mechanism that is being proposed. I'm just going to describe here what is being submitted to them for formal endorsement by March 2020. So, sorry. Now, before describing what reforms are being envisaged under the OIC investment dispute settlement protocol, I wanted to highlight, as you may already all know, that there are a lot of concerns about the current ISDS system. For us, we can group them in three categories of concerns. So these are the concerns of the developing world, right, regarding the current system. To me, there are three categories. There are sovereignty concerns, there are legitimacy concerns, and there are capacity concerns. When we talk about sovereignty, we all know, the current debate talks about the regulatory chill and constraint on the right of the state to regulate. You may know that states are being brought before arbitration, ISDS case, and in many cases because they have adopted measures, to regulate, for example, global and national objectives like environment, public health, or whatever. So one concern is for the developing countries whether the current system doesn't put a constraint on their right to regulate. So the second concern is in relation to the development of domestic judicial institutions and domestic rule of law. So arbitration is, as we all know, an external system for resolving dispute. Now, it has impacts, therefore, on the autonomy of the internal judicial system and internal rule of law. So developing countries have concerns when it comes to disputes that are related to public matters, on which ground such kind of dispute should be addressed at the level of private institutional arbitration, being a private means of dispute settlement. So that's also a sovereignty concern. Now, in terms of legitimacy, that's all what we are hearing about, independence and impartiality of arbitrators, inconsistency of disputes, of arbitral awards, and all these things. So you have arbitral awards, deciding on similar cases, but having different way of deciding on it, or different interpretation of similar provisions. So the issue of inconsistency is there. One other concern that impacts the legitimacy of the current ISDS system, as you know, is also the lack of appellate mechanism. States are worried that sometimes a decision is taken or an award is taken on a matter that is related to public order, for example, and yet they don't have an opportunity to appeal such kind of decision. So the lack of an appellate mechanism for arbitration on public issues is also a concern. There is also issues about frivolous claims, third-party funding, the impact that ISDS has on non-parties to the disputes. So all these things, I guess you have enough reading on this from the CCSI publications, and I know they have good publications on all these issues. So all these issues are related to the legitimacy. And lastly, the third category of concerns that developing countries have, including the OIC member states, is the capacity issue. When you have a dispute between an investor and a state, often the relationship is unbalanced, and an investor has enough means to go to arbitration, to have the best lawyers to defend his own interests. Developing countries don't necessarily have that. So there is a lack of level playing field when it comes to this matter, and also a lack of competence in many cases in our member countries to address disputes relating investor-state disputes. So these claims are often sophisticated, and the capacity is not there. So to me, these are 10 concerns grouped in 3 categories of issues that the developing South including OIC member states, because OIC member states are all from the developing world. So these are the kind of concerns they have. Now, and these are the concerns that are on the table at the UNICITRAL Working Group 3 as well. When we started doing our work to reform Article 17 of the OIC Investment Treaty, we had to take into account these concerns and see what kind of policy responses we can bring to solve these issues. And that's where what I'm going to talk about now quickly. So basically 6 points. I'll start with design principles. So we first started by saying that we need to limit ISDS. UNICITRAL started its work by saying whether a reform is desirable or not. For us, it was very clear a reform was desirable, so we didn't spend much time to think about it. So, and we decided that we need to limit ISDS. Now, by which means, that's what I'm going to talk about later. We also thought that we need to institutionalize dispute prevention, right? It's not that a dispute occurs and then we just need to go to arbitration. It's kind of establishing a filter mechanism whereby parties would first look at resolving their disputes amicably before having to resort to ISDS. Finally, we thought that it's important that in designing the system, we observe some key principles. So subsidiarity, transparency, participation, accountability. These are key principles that were developed in a book that CCSI sponsored, and I was happy to be invited to be an author in this publication. And for further details, you may refer to that book to know what all these principles refer to. But bottom line is that when designing our mechanism, we clearly relied on these principles to come up with something that would give more legitimacy to the system. So in terms of design principles, these are the things we considered. Then it helped us to design an architecture. What the new dispute settlement mechanism under the OIC investment agreement should look like. First of all, we identified 4 components that should be part of the architecture. The first one is that we need to have a policy forum, right? Because in the end, these matters are really have some political, influence. So we need to have a policy forum to be part of the architecture to play a certain role in dispute, not in dispute, but to certain role in terms of the governance of the framework itself. What is the specific role, for example, of this policy forum? OIC agreement, as I said, is very old, but yet we don't have time to reform it because we cannot engage the two work streams of reforming the OIC investment agreement and reforming the dispute settlement system. So what we came up with is this policy forum, which will be made of ministers of member states, trade or commerce or investment, would be convening to interpret provisions of the OIC investment agreement. And those interpretations would be binding on arbitral tribunals. For example, provisions would be on a fair and equitable treatment, or provisions on MFN provisions, all this. So these are old. If you look at OIC investment treaties, these are old provisions that are not necessarily reflecting sustainable development objectives. So the policy forum will have a role to play there by issuing interpretative declaration on those provisions, and those declarations are going to bind arbitral tribunals if at all a case has to go to ISDS. Dispute prevention, as I said earlier, that's one of the additionality we are bringing there. We think that dispute, as I said earlier, before going to ISDS, need to be attempted to be resolved amicably, and not necessarily between investor and state. And here what we thought is that the two states, for example, Senegal, I'm an investor from Senegal and I'm going to invest in Indonesia. both countries are party to the OIC treaty. So I have a dispute with Indonesia where I'm investing. So my country, Senegal, and Indonesia would sit to try to address the issue, to settle the dispute amicably before I have the right to go to arbitration. Now, thirdly, the third element of the architecture is the two-step adjudication mechanism. And as I said earlier, one issue is that you don't have appeal mechanism in current arbitration. So here we are introducing two-level first instance panel, like very similar to what we have in our judicial systems, a first instance panel which will be made of permanent adjudicators from OIC member states and outside OIC member states, who will hear cases on first, at first instance. And if at all there are issues, and one party is not happy, there is a right to appeal. And I'll come to that part when I will be describing how the dispute settlement system will work. And then in the end, the fourth component is the dispute settlement organ secretariat. This whole thing has to be managed somehow. When a dispute occurs, obviously parties need to have an administrative body where they can submit the case for registration and for managing, on cases when they occur. So this is basically the architecture with 4 components. Now what I'm going to describe is how a dispute between an investor and a state will flow. Now, suppose a dispute occurs. Let me take again the example I gave. I'm a Senegalese and I'm investing in Indonesia. Senegal and Indonesia are party to the treaty. Now I have I go invest 100 million in Indonesia, and my investment is expropriated. Now, what we are saying is that before even being in the current system, I would just raise an arbitration, initiate an arbitration, and a panel will be established to hear the case. What we are saying is that first now you have to exhaust the local remedies. That's one additional filter also that we are putting there to limit ISDS. So I will have to first try the judicial system in Indonesia before I'm able to come here. So these are all the steps I will have to cross before coming here. And here what we are saying is that I go first to the national judicial and judicial system before I'm able. Now, if I go there and I'm happy with the decision that that was issued, then the dispute ends there. If I'm not happy, then I have to go to try to settle the dispute at the state level, as I said earlier, which is the dispute prevention mechanism. But here also, it's not in all cases. The ground for me doing that should be that there has been a denial of justice in the case when I went to the judicial system, national judicial system. In cases where there are denial of justice, then I can take the dispute further. And at that point, I go to state. So Senegal, a commission is probably established between Senegal and Indonesia to try to address the dispute. And if it's successful, it ends there. If it's not successful, it's there where I have now to go to the first instance panel, which is a panel of 3 judges, adjudicators, who will be taken from a roster to be established, and then to hear the case. Now, the panel will issue a decision. If the decision is not challenged, so the dispute ends there, and the aggrieved party has to enforce. If I'm not happy with the decision, then I have the right to go to an appellate committee, which is also a standing body that is going to be established. And from there, the outcome of the dispute of the appellate committee decision will be final, and we will have to enforce. So basically, what you see currently in the ISDS system that we know, when you have a dispute here, you just go directly to an arbitration panel. From what we are proposing, you have to cross now all these steps before coming to here. But not only that, but we are adding this component now, which is the appellate committee, which doesn't exist currently in the arbitration system. So that's the system mechanism we are proposing for the OIC investment dispute settlement system that is under preparation. Now, as you know, investment treaties have also provisions on a dispute can occur under an agreement between two states in terms of interpretation or whatever. So that is not a dispute between the investor and a state, but that is a dispute between two states in terms of interpreting. So this is the system we are also proposing for those kind of disputes. So it is basically the same, but except that the two states have to try to settle amicably first, and if it doesn't work, they go to the two-step adjudication mechanism, that is the first instance panel and the appellate decision. Now, the other, as I said earlier, in terms of capacity is one of the concerns of the developing South when it comes to the current ISDS system. And that's why, as part of the protocol on OIC investment dispute settlement, we are proposing to establish an organ that, that would be assisting member states to face claims that are brought against them, to raise their capacity to defend them before, under the two-step adjudication mechanism. The mandate of that facility would be to provide legal assistance to member states for them to be able to respond to disputes. We are also discussing whether the mandate should also extend to providing capacity building, but there is a lot of discussion around that, but we'll see whether we'll need to extend the scope of the work of the legal assistance facility to providing capacity building. And finally, what I can add about the legal assistance facility, it's going to provide annual reports to the policy forum, as I said, which is a political organ that does not get involved into disputes, but that is just at the level, at the macro level, to oversee the overall functioning of the system. So it's just like the admin council at the World Bank or the WTO, what you call it again, the ministerial forum or whatever. Third-party funding is a concern of current arbitration system, frivolous claims, and all these things. But what we are proposing now, instead of addressing those issues as part of the protocol itself, which is a treaty to be adopted, these issues will be later discussed and agreed as part of the rules and procedures of the dispute settlement organ of the two-step adjudication mechanism. That's where, in their rule, we'll discuss and regulate third-party funding and frivolous claims. So basically, to conclude, I drew this table just to give you a picture of what the reforms look like. As I said, there are these current concerns about ISDS, sovereignty, legitimacy, capacity. The OIC reform proposal to address sovereignty issues, as I said, to establish a policy forum which shall have mandate to interpret substantive provisions of the OIC treaty to prevent and thereby prevent regulatory chill. The second reform to address sovereignty issues is the exhaustion requirement now to exhaust local remedies, thereby reinforcing domestic judicial institutions and domestic rule of law. Now, when it comes to the concerns relating to legitimacy of the ISDS system, what we are proposing is to establish a permanent dispute settlement mechanism, as I explained earlier, which will help address consistency, independence, and impartiality issues. Cost issues also will be addressed because arbitration is costly. But as part of what we are going to propose, we'll regulate costs. So costs will be regulated as well. A second measure being proposed to address legitimacy concern is the introduction of an appeal mechanism, as I said. ISDS also will be limited to denial of justice claims, which is not the case currently. state-to-state dispute will be introduced as a filter before going to the first instance panel or the appeal. Third parties will have also a right to participate in the dispute. That is also a proposal that we have introduced in the draft protocol to be negotiated, whereby third parties who feel interested in a case may have the right to be party to those disputes. And then third-party funding will be regulated, as I said, as part of the rules and regulations of the organization, and frivolous claims as well. And to conclude, in terms of capacity, and this is the last point I just explained, we are going to have an advisory center to be established as part of the treaty to assist member states in facing investment disputes. So I just want to conclude by saying that all these what you are saying are on the table of UNICITRAL Working Group 3. But we just feel that we are we have a case study, we have a concrete case where we can implement it. So what is going to happen with UNICITRAL? They will discuss all these issues. Member states will give their views, decisions will be taken, and then they will have to look for ways to implement all this by establishing a multilateral investment board or whatever. For us, we are already advanced because we have a concrete case where member states have already decided that they want to reform the current Article 17. And we are observing what's happening at UNICITRAL, and taking stock of whatever we feel help address our issues, but we are kind of far ahead in terms of reform proposal. Now, for example, third-party funding and frivolous claims, these are issues that we don't know yet what would be the outcome of UNICITRAL discussions. There are different views. That's why we said we park them until we start developing the rules and regulation of the organization to see what we can take from there. Although we have already a view in terms of whether third-party funding should be allowed or not. My personal view is that it should not, but that remains my personal view. Member states will have to decide. We'll have to give some proposals to them to see what they finally decide. So thank you. I mean, by this I end my presentation and remain open for further discussion. Although I'm limited in terms of the responses, because there are a few things I may not be able to say. I would have loved to talk about the current disputes going on and all these things that motivates the need to have this OIC new system. But unfortunately, besides what is already public and which you could find in the internet, I'm not allowed to talk about those things. Thank you.
Yeah, sure. All right, thanks for coming and sharing with us. I just have two quick questions. First is that we were talking about the South-South contribution to the reform itself. I'm just wondering what would be the incentive for the investors to actually resort to the mechanism under the OIC investment agreement instead of the BITs that they have. For example, Indonesia, I'm from Indonesia, and there are a lot of investors coming from mostly East Asians, UK and US. We have a few investments from Middle East countries, but I would say that some of the investors would choose to go to the BIT because they don't have to go through the two-tiered or the multilateral investment court and have to go through exhaustion of local remedies. So what would be the incentive for the investors to choose this instead of just relying on the conventional method under the BIT? And second of all, on the policy forum between the ministers of the countries, I'm just wondering, what's your view on whether this is going to be feasible or not? Even in exit, states have diverging views and interpretation of the clauses, and states deliberately avoid to interpret certain provisions, and they just leave it open when they discuss the exit convention in the past. So whether the states would agree on something if they have a very, very divergent types of policies on certain issues, whether that is a feasible mechanism or not.
Yeah. Let me take the first question, because these are very good questions, and we have been actually discussing about those questions. But ideally, let us not forget OIC is a cooperation organization. So member states have bilateral investment treaties, yet they have also a multilateral investment treaty. What we are campaigning for is that once this mechanism is established, to become the mechanism for even BIT disputes. So they may have to either terminate their current BIT disputes and just rely on the OIC agreement. That's one way of doing it. The other way is that to amend their BIT provisions, which talks, because at the end investors are party, yes, but it is a state instrument. A BIT is still among two states. So if they feel that this OIC mechanism is giving them more protection, right, and is more in line with their sustainable development objectives, they may agree to interpret their BIT or to amend their existing BITs to say that disputes arising out of the BIT would be settled through this mechanism. But it's their judgment. At the end of the day, here we are not talking about investors, we are talking about state matters. So states are the ones who are going to decide on whether they want to keep the dispute settlement system under the BITs or whether this is more in their interest. The question you would ask probably is whether this new system will still protect investors and give incentive to protect for investors to come to invest within the OIC region. But at the end of the day, what studies, empirical studies have proven that signing an investment agreement is not necessarily an incentive for attracting foreign investment. So at the end, the cost is higher than the benefits. So that's I think the two answers to your first question. State may consolidate and then terminate the current BITs and just rely on the OIC investment agreement, which is a macro framework. Or if they choose to stay within their BITs system, they may still interpret, and refer their disputes and the BITs to the OIC system. But at the end, it's a political choice. It's the sovereign decision. We are just putting the framework for them to be more in line with modern sustainable development objectives. But they are the ones who decide in the end. So the second question, if you can remind me, sorry, I don't have.
So the policy, where ministers gather and then make recommendations on certain interpretation of provisions, like how feasible do you think that can be implemented, given that OIC states have very different types of economy, different views and.
Yes, what is clear is that they may not agree on everything, but there are things they will not disagree on. If you take the provisions of the OIC agreement, those substantive provisions, I wouldn't say that, case law has shown that these provisions are not necessarily reflecting what they intended when they were signing the OIC investment agreement. So, and case law, not only OIC case law, general case law, investment dispute settlement has shown that those provisions are not in the best interest of states as drafted until they amend them or restrict them or revise them or interpret them. So what we are sure is that states will naturally agree on a minimum. They may not agree to wider interpretation or no, but that is left to them. And a decision, there will be ways to, voting, this policy forum will have also voting rights and voting mechanisms whereby if a state doesn't agree but the majority agree, the decision will be taken. So at the end, it remains a political will and political decision. There was a question there.
Yeah, thank you for this brilliant presentation. It was really enlightening. My concern is regarding the legitimacy and neutrality of this mechanism, considering it's based and headquartered in Saudi Arabia. The current Secretary General is a former Saudi cabinet minister. So would that not automatically deter some countries, such as Iran and other states which do not have that friendly relations with Saudi Arabia, and generally the Gulf countries they tend to enjoy a lot of influence in most of your regional bodies. So countries such as Qatar, Syria, Iran, which are not in good relations, and even there was a dispute between Turkey and Pakistan, the Karkay case. We don't see that coming to towards OIC, but rather going to ICSID through BIT. So that's one concern I have. Secondly, regarding this requirement of going towards local remedies and then a post-appeal mechanism, how does that correlate to the entire argument about this mechanism wanting to reduce costs? Because one of the major costs incurred is through the legal fees rather than the arbitration in itself. So because the entire time period of this process is far longer, on paper at least, compared to an ICSID one, the cost would automatically be a lot more than they would be in any other mechanism.
Yeah. Thank you. These are, again, excellent questions. I think we should invite you all to the exclusive meeting so you can enlighten us with all these questions. First question is very pertinent. I guess you have probably read through the current memorandum of arbitration that have been submitted by some investors under the OIC investment agreement. That's maybe where you are deriving the issue of political OIC Secretary General being a Saudi, and because these are public the memorandum of arbitration where these issues are being raised by arbitration by investors to delocalize the dispute to the Permanent Court of Arbitration and UNICITRON. So there are cases like that. But the answer to this is this. The fact is that you have an OIC investment treaty. When member states were signing it, they signed it, and the secretariat of the OIC is in Saudi Arabia. So that's what they subscribe to, no matter what the current geopolitical situation is. Now, the fact and that issue of political issue, we are trying to also address in the system by making sure having these panels and the appointment of arbitration. Because currently, for example, if there is a dispute between a Saudi, an investor against Saudi Arabia, the Secretary General being a Saudi may refuse to appoint an arbitrator if the two parties refuse to appoint an arbitrator. That's one thing. But the way we are trying to address this political concern is in the way you are going to appoint arbitrators. And the arbitration is not, or the dispute is not going necessarily to be settled. The seat of arbitration is not going to be necessarily in Saudi Arabia. So I may be sitting in Senegal, I have an issue with Indonesia, and then I raise the arbitration before the secretary, before the dispute settlement organ, which basically is not, it's not yet decided that it's going to be in Saudi. Currently, Saudi, the OIC Secretary General, Secretariat being the depository of the OIC treaty, is the secretariat that receive dispute claims and all these things. But in the system we are designing, it's not necessarily going to be the case. It may be that, for example, the system is going to be attached to the Islamic Development Bank in one of its offices somewhere in Dakar or in Morocco or wherever. So it's not necessarily that the whole system is going to be in Saudi Arabia, right? It's not necessarily that this whole system is going to be linked with the OIC Secretary General. So, but bottom line is that these are valid concerns which member states have to decide themselves. What we are hoping is that at the time of the negotiations, they are going to raise some countries are going to raise and are going to make some requirements for having the system more neutral, but at least as technicians, we are building in the system tools that depoliticize the whole system in terms of the way you are going to appoint. If the Secretary General, maybe the Secretary General is not going even to be the default appointing authority in case the party is not appointed. The seat of arbitration is not going to be necessarily in Saudi. It could be anywhere the parties choose for the seat to be. So we are learning lessons from the current system, right? From the current system to also build up, to address some of the issues that we have seen in the current system. So your second question was?
Regarding the cost, you said that you want to regulate costs and reduce them.
You see, at least as far as I'm concerned.
I think it's the microphone.
Yeah.
Yeah, just that piece, yeah. Put that on the lapel. Yeah, perfect. Yeah, great. Or just hold it.
You can probably hear me.
Let me just put it right here. I think you can hear me, right? You see, cost issues are normally here at ISDS level. So whatever happens here, right, at the level of the states, may be costly, but when we talk about cost today in the current system, it's really the cost of arbitration. I don't think in our member countries the cost for access to justice is expensive. I don't think so, right? And at that level, we are still not controlling anything. We are just saying, as a national of a member state, you have a dispute, go through the national system, go the way it is required to raise your claims, go through all the steps, but we are not going to be involved at that stage. What we can regulate is from here. And from here, we are clearly regulating the cost and the timeline as well. If you see the protocol, in the protocol, we are defining milestones, steps, and dates and periods. You cannot exceed this number of dates for filing an appeal, for the panel to hear a case and all these things. That's one. Second, so time is going to be regulated. Secondly, fees are going to be regulated. So it's not like in the current system where the longer the dispute is, the more expensive it will be on the party. And we are also going to regulate costs in terms of who is going to take the burden of payment in certain circumstances. In some cases, it would be both parties. In some cases, it would be one party. So all these things we have already formulated some proposals in the protocol. Now, states are going to negotiate these aspects as well. But really, yes, as I said, one of the concerns is also to regulate costs. And we are going to be having clear timelines, at least when it comes to this part, right? And regulating also the amounts to be paid and all these things. I had another question. I'll get back to you shortly.
Can you move to the next slide? The state to state?
Next slide.
Yeah.
Yes.
Okay, so is this for interpretation of the
Yes.
treaties? Okay.
For interpretation, but also don't forget that state to state is also one of the filters at the investor state dispute level system.
Yes, my question goes to the interpretation part. So, if there's a decision of interpretation, would that be an amendment of the treaty, or that would be a standing decision? Because if it's a standing decision, meaning an arbitration decision between the states, I find that hard to be brought in an investor state case because it's not an amendment to the treaty. So if the two states don't agree on something, they go to arbitration and the arbitral tribunal says this terms means X. That's not, from my point of view, an amendment to the treaty.
So are you talking about the decision here or here or here?
So what I'm saying is, if the two states decide together, they can amend the treaty, right? So if there's an agreement, a negotiation, they can amend the treaty.
Yes.
If they go to arbitration between the states regarding, let's say, the interpretation of whether mining is an investment, and the decision of the tribunal is mining is not an investment according to this treaty, that decision binds the two states.
Yeah.
But does not amend the treaty.
No, absolutely. It's not an amendment of the treaty. It's just on a specific case, they have a dispute, they go to this and interpretation, and the tribunal decides something, it bounds them.
Okay.
It's not going to bind the other parties. If at all the member states want to amend the provision of the treaty, they will have to go through the amendment provision in accordance with the amendment provision of the treaty.
Makes sense.
So this would be just for a specific case, and they would just, to solve a dispute among themselves.
Okay.
Just one last question.
Sorry, I had a question.
Sorry.
You touched upon PCA's intervention in the OIC arbitration process. What is the perspective of OIC towards this other interference in the OIC investment treaty or arbitration process? Has that been an issue of discussion in establishing this permanent mechanism?
I'm not sure I get.
So, like in the case of Libya and Oman, they refused to nominate arbitrators, and then the investors took it to the Permanent Court of Arbitration, and then they made appointments for the arbitrators, and the tribunals are constituted. Does OIC have any opinion on that, and how has that affected your discussions?
That is something I cannot comment on. I get your point, definitely. But yes, there have been cases where this has happened, where the investor has decided to externalize the dispute by calling on UNICITRAL, using actually the MFN clause that is in the OIC agreement, to invoke UNICITRAL as the most favorable dispute settlement system, because on grounds that the Secretary General will not appoint because he has failed to do so previously. So, and then on that ground, they have wanted to externalize the dispute using Article 11 on MFN clause to take it to the UNICITRAL, and thereby asking the PCA Secretary General to appoint the third arbitrator. That has happened. Now, there have been cases ongoing where the issue is still there. But whether the Secretariat General has a position on this, unfortunately, I cannot comment on that.
Okay, great. Thank you very much.
There was a question.
Yeah.
I would feel bad if I'm not.
Okay,
I'll make it very brief. So in many respects, the history and current status of the OIC agreement is similar to a multilateral treaty existing within the Arab League. And in particular, here as there's an issue of what to do in the interim until a larger court or dispute settlement mechanism is established. And so in the Arab League, they have an investment court in Cairo, but they had envisioned creating a larger body similar to what you're doing now. And so my question was, in your reform efforts, did you have any contact or recourse to what they were doing to reform their multilateral treaty and standing body as you were creating your own?
Yeah, I guess you're referring to the Arab Investment Court.
Yes.
Yeah, there is also a treaty among some few Arab countries of the Gulf, and I think Middle East as well on invest. So they have already a dispute settlement organ which they're trying to reform. Mm-hmm. But don't forget that that organ is competent only for claims arising out of that agreement.
Right.
So the organ we are setting up will be competent exclusively about cases that will be brought out of the investment treaty, OIC investment.
I guess my question was, in the process of affecting reform that you were doing, did you look at the way they were affecting reform within their?
Yeah, absolutely. We looked at their current system. We learned from the weaknesses they had in the, because that system didn't work as originally designed. So they are reforming, hence they are reforming it. So we took stock of all this. What they did, what worked, what is going to under discussion at UNICITRAL, what are member states that are participating in UNICITRAL, what are they saying, Morocco, Indonesia, all these countries, what they are saying. We took stock of all this and are coming up with this proposal with the hope that when we will convene the expert group, will reduce the level of opposition and have maximum adherence to the proposals.
Thank you.
Thank you.